Thank you everyone for joining us for another Learning Lunch hosted by FormatApproved.com. My name is Brian Johnson. I'm the Senior Director of Online Education with Format Approved, and I'll be your moderator today. Today's Learning Lunch is titled, HIPAA Business Associates Need to Be Compliant Too. We're joined today by Mike Semel of Semel Consulting. Mike is one of the top HIPAA experts in the country, and we work closely with him here at Format Approved. Mike has worked extensively with business associates to bring them into compliance and has really been deeply involved in helping people with the Omnibus Final Rule. So you could not ask for a better resource to address today's topic. You can see the rest of just a sample, actually, of Mike's credentials there on your screen. Remember that you can ask questions of our presenter at any time during today's session by entering them into the chat area. In the second half of our session, we'll address as many questions as time allows. If we do run out of time, answers to all those submitted questions will be posted to our website and sent via email link later in the week. Also note that all registered attendees of today's session will receive an email with links to both the slides and the recorded versions of this event. So if you want to look over the slides later, we'll send those along to you. Well, first of all, Mike, thank you for joining us today. It's always a pleasure to have you with us.
Glad to be here, Brian. Hope everybody's enjoyed their Thanksgiving weekend and is now ready to get back to work.
All right. Well, let's get down to some compliance here. What are some examples of business associates? Who counts as one?
Well, let's go back just for a second and talk about the covered entities, many of whom are on this call would be the medical practices, hospitals, all the medical providers that you would normally think of, and the payers of health care benefits. So the health plans, the large health plan companies, Medicare and so forth, are covered entities. So they're the ones entrusted with the patient data, and they bring in business associates to help them do things with their businesses. So for many smaller practices and hospitals, there are outsourced IT support companies that provide technical services. You have lawyers that represent doctors in lawsuits and collections, and I'm going to distinguish those from the lawyers that you see advertising on television and on billboards. Typically they represent patients, and the patients can give them the medical records, and that does not make them a business associate. But if a doctor is sued for malpractice, or if the doctor is going to use a lawyer to help collect unpaid bills, they're providing medical information to help with their practice. Since they're a covered entity, that makes their lawyer a business associate. You have accountants that audit healthcare organizations. They go in, and when they're doing their auditing, they're often seeing patient information and tracking the payments, the co-pays, insurance payments, and so forth. Shredding companies, paper storage companies, and even though we're moving to electronic health records, there's still a lot of paper that's going to be stored for a long time based on the retention rules for Medicare and what the states require. A lot of people that support healthcare organizations, and not just small ones, are contractors. They're not employees. So they're contract transcriptionists, and recently I spoke to a group of coders, and several of those were independent businesses that contracted with medical organizations to do their coding for billing. Revenue cycle management. There are a lot of different companies, and they do different things, but ultimately it's to work with healthcare providers to make sure that they're getting the maximum revenue for the services that they're providing. And then I'm throwing a catch-all in here that says anyone that sees or stores your PHI, that's protected health information, in the course of their work in supporting you. And then the HIPAA Omnibus Rule extended the business associates' responsibilities to any subcontractors that they work with to store or process patient data. Subcontractors could be places like data centers where servers are housed, or cloud services, or online backup companies.
So tell us more about your involvement with business associates, if you would, Mike.
Well, I've owned several companies that have supported healthcare organizations. So I was actually a business associate at the beginning of the HIPAA security rule implementation back in 2005. We had healthcare clients when that rule kicked in. We had to do things to comply, even though we weren't directly liable for any penalties. We still had to prove to our clients that all the work that we were doing was compliant and was not going to put them at risk. One of our companies created a online backup company. So we've had some different experiences here. I worked as the chief information officer for a hospital, which actually made me a covered entity, but I was responsible at the hospital level for making sure that our vendors were compliant. So that put me kind of on the other side of the fence, making sure that the vendors that we were working with were compliant. Again, we were the ones responsible if they did something wrong, and we had to make sure that everything that we were doing was compliant and being able to prove that they were also compliant because we had all the risk. And then recently, in the last few years, I've consulted with literally hundreds of business associates, including some large corporations, mostly in the IT world, cloud services, online backup companies, and so forth, so that they could become compliant because with some of the recent changes, they now had to go back and look at what they were doing to make sure that everything was compliant with HIPAA.
Well, you've certainly come at it from a lot of different angles then. I especially like the angle of when you were working as a CIO to work with your vendors to be compliant, but then, of course, also your individual work with BAs. And it really illustrates that BAs come in lots of different shapes and sizes, too, down to individuals or large companies. So let's talk a little bit about how things have changed. The HITECH Act of 2009 changed things, and then the Omnibus Final Rule of 2013 implemented a lot of those changes. How has all of this changed the rules for business associates?
Well, as I said a minute ago, in the past, business associates had to protect the data. I mean, they still had to comply in many of the same ways that they have to now, except if there was a data breach, they were not directly liable. The way that the original HIPAA laws were written, the business associates were left out when it came to enforcement. So even though business associates created data breaches, the people that had to pay for them and paid the price for those breaches were the covered entities that had brought the business associates into the picture. So the issue began way back when, way back in 2003 when the HIPAA security rule came out. And if you think back to that time, 10 years ago, in the last 10 years, an awful lot has changed in the technology world in particular. And we can now do things like online backups, and we have cloud vendors and data centers. And a lot of that came from the broadening of how much internet speed and access we could get. So as broadband took over from the old slow dial-up and DSL connections, all of a sudden we could do things remotely that couldn't be done before, and a lot of businesses sprang up taking advantage of that bandwidth and the performance. The other thing that happened was that the cost of storage came down. Hard drives used to be very expensive on a per megabyte or per gigabyte basis, and now that cost is way down. So what's happened is that we now have cloud-based electronic health record systems where the servers are not located at the medical practice as they had been in the past. They're located someplace else, and they could be at a data center where the medical practice owns their own servers, or they could be buying technology as a service. So now what's happened is that the government recognized this, and in the HITECH Act back in 2009, which was not implemented until the Omnibus Rule was written by the Department of Health and Human Services and released earlier this year, now business associates are directly liable for HIPAA penalties. They're also responsible for their own compliance and any subcontractors they use. So I just talked about the online backup companies. A lot of IT companies sell online backup services to their customers as part of the managed services that they offer. And in that context, the business associate for the covered entity would be their IT company, but the subcontractor that is actually storing the data would be the backup company. So the IT company is the business associate. They're now responsible for their own compliance, and they're responsible to their covered entities, to the medical practices that they work with, to guarantee that the subcontractors that they're using are also compliant. The other thing that the Omnibus Rule did was that it clearly expanded the definition of business associates to include data centers, online backup providers, cloud services, paper storage facilities, and others that process or maintain protected health information, and they even added the verbiage that said even if they do not look at it. So this is different than what has occurred in the past where these organizations, the data centers and the cloud services, would say that they didn't have to comply with HIPAA because all the data that they stored, for example, was encrypted. And now this rule does not exempt encryption from qualifying as a business associate. There's some confusion here because encryption still is an exemption if data is breached. If a laptop, for example, is lost and the data is encrypted, then you don't have to report it as a loss. However, it does not exempt a company that stores encrypted data from being a business associate. So all those companies that store data, even if it's encrypted, even if, like in the data centers, they're in locked cages and locked cabinets, and the data center staff can't get to the equipment, based on this new HIPAA Omnibus Rule, those data centers and the cloud companies are now business associates and directly liable for HIPAA penalties.
Well, you know, we're going to talk about this more as we go through the slides, and I know there will be questions about it, but we were chatting even before we began. It seems to be so much confusion, or if not confusion, in many cases outright denial, I think, from data centers and those providers who just haven't grappled with this, basically.
Or don't want to grapple with it.
Right. So those are some of the changes. What didn't change?
Well, what didn't change is that the risk for the covered entities was not reduced. In fact, if you think about it, it was actually increased. So when the law was written, the HITECH Act was enacted back in 2009, and it said that business associates would have to comply. There was kind of an assumption that that was shifting risk away from covered entities, the medical practices and the hospitals. However, that's not the case. That covered entities are still fully responsible. And the analogy that I use, Brian, is, and I know you never do this, is that if you brought a friend to a party and they got drunk and they damaged the furniture, they're not the only ones that are going to be blamed. You're going to be blamed for bringing that person and maybe using poor judgment, but also the person that invited you is going to have some skin in the game, some risk, because somebody may say to them, why did you invite this person who brought this other bad person? And that's essentially the way that the Omnibus Rule is looking at this, that covered entities are still responsible. So if a covered entity, a medical practice or a hospital or a payer, hires a company to handle their IT, for example, and that IT company brings in an online backup company, and there's a data breach at the online backup company, the federal government considers everyone down the line liable. Now, it doesn't mean that everyone's going to get fined, but there still is going to be a risk for the covered entity because their vendor did something wrong. So covered entities still can be fined for violations and breaches caused by their vendors. And by expanding the definition of business associates down to these subcontractors, now a covered entity could be fined for the actions of somebody that they've never heard of. And we're going to talk about how to protect yourself against that.
Has this caused problems then with the business associates in particular?
Yeah, and this is what we're seeing and it's actually going from a pretty wide spectrum. They're business associates, and I see this every day in what I do. I get calls from medical practices, I hear from IT companies, and I deal with a lot of vendors. And I was recently at a very large IT conference and saw a lot of companies that were advertising themselves as HIPAA compliant. What we're finding is that there are still some companies that are unaware that they have to comply. Even with all the publicity, even with all the information, particularly since January when the Omnibus Rule came out, it's surprising to me that we'll talk to a company and they're clueless that they have to comply. And in some cases, we're hearing from IT companies that they're talking to because we've educated them through workshops and through webinars and things like that, that they have some responsibility if they have medical clients. They're telling us they're going to the medical clients, and the medical clients are unaware that they have to do anything with business associates. So it's still surprising that every day or every week we're hearing from someone that's really surprised that they have to comply and they're scrambling to do it. There are others who have looked at this as a legal exercise, not a compliance exercise. And they think that all they need to do is sign business associate agreements, and that means that they're compliant with HIPAA. And that's not true. The business associate agreement is important, and it's a fundamental part of HIPAA compliance. However, many of these companies have talked to lawyers, and the lawyers, will tell them, we'll make up a contract with you, and once you sign those, you're HIPAA compliant. That's not good advice. And I work with a lot of HIPAA attorneys and talk to them on a regular basis, where they're saying that they're trying to explain to their clients that this is more than a legal exercise, but we still see organizations that have their own in-house counsels and also attorneys that don't specialize in HIPAA that think that this is just an exercise in signing contracts. There are some companies that are actively denying that they have to comply. And I see this, and I can find it every day when I look at websites and see companies saying things like, well, we're not a covered entity, so we don't have to comply. These may be old, this may be old information on websites that have been around for a long time, but certainly since January of this year, they've had to start a compliance program, and by September 23rd of 2013, they fully had to comply. So there shouldn't be any company that says it doesn't have to comply that's in one of the businesses that I described, because based on the definition, they are a business associate. Some data centers and cloud services are claiming that they're exempt because the data is encrypted. And as I said before, encryption is only an exemption for data breach reporting, not for qualifying as a business associate. They're two separate sections of the rule, and they don't relate to each other. I've seen some companies say that because the data that we store is encrypted, we don't have to sign business associate agreements, and we don't have to comply. It's not true based on the new rule. And then, unfortunately, and these are things that I've seen firsthand, and I'm not going to mention names because it could create legal issues that I'm simply not willing to deal with. There are companies that are fraudulently saying that they're HIPAA compliant when they aren't. And I have seen this personally with companies that have contacted us and are talking to us about what they need to do to be HIPAA compliant while they're advertising in their websites, and their salespeople at conferences are shouting as loud as they can that their company is HIPAA compliant when we know otherwise. So this isn't something that I think might be happening. I've actually seen it several times just in the last month. And these are companies that people should really be afraid of. And we're going to talk about how you can protect your medical practice if you're going to deal with someone and have a better feeling of confidence that they really are complying.
So you touched on this before, but if the business associate now with the new rules is liable, why is the medical practice still liable? Shouldn't it just be the business associate then?
Well, no, Brian, because we're all patients, and we're entrusting our medical providers and our insurers, the health plans, to protect our data. If they choose to bring in a specialist, so I wouldn't expect my doctor to have an IT staff, because in a small office it's not practical to incur that kind of expense internally. So I have no problem with my doctor using an outsourced IT company as long as they're going to do things right and secure the data. So I'm trusting my doctor with my patient record. Going back to HIPAA, at the beginning of HIPAA, back in 2003, when the privacy rule kicked in, it really said that patients now owned their data. They had the right to manage or to determine who had their data and what could be done with it. And the Omnibus Rule in 2013 made a few changes to that, which is why practices needed to change their notice of privacy practices. But essentially, this is a chain of trust. So the patient trusts the covered entity, their doctor, with their patient record. The doctor has to find vendors that they trust to protect the data at the level that the government says is required. And then the covered entity's business associate now has to choose their business associates, their subcontractors. Again, think organizations like cloud vendors and data centers and online backup companies, to properly protect the data, because that's where it's going to end up. So covered entities need to choose their vendors closely, and then they need to monitor them and make sure that they're compliant. We're going to talk about some examples of companies that had vendors not do a good job, and there's some lessons that can be learned from that.
What about the agreements themselves? Have the rules for the business associate agreements changed too?
Yes. So going back to the early days of HIPAA, the business associate agreements have been required, and frankly it's been an area where a lot of medical practices and providers have been weak in getting these signed and making sure that their business associates are properly identified and have the agreements in place. But in January of this year, January 17th, the Omnibus Rule came out. January 25th, Health and Human Services published new wording to go into business associate agreements. So new vendors have to sign new agreements. So if you're picking, if you're a medical practice and you're going to pick a new business associate, they have to have an agreement that complies with the 2013 wording. The existing business associates, companies you've been working with for a long time, if they had an agreement before January of this year, they still can work on that agreement until September 22nd of 2014, but they had to comply with the new HIPAA regulations by September 23rd of this year. This has caused some confusion out in the business arena, because when people saw the September 2014 date, they thought that companies were, for example, grandfathered on the old agreements. That's not the case. Anybody that had an agreement prior to 2013 can still work under that contract, but the contract, just the paperwork, has to be replaced by 2014. It did not mean that they don't have to comply by September of 2013. So all business associates, whether they're on an old contract or a new contract, should have complied with HIPAA by September 23rd of this year, even though the practices and the hospitals and the payers have until September 22nd of next year to replace the paperwork.
Yeah, I think that has caused a lot of misunderstanding. So people have a little bit of time to replace those contracts if they're already in place, but they still have to comply with the new rules. So what's the rationale for all of this, Mike? Why do business associates have to comply with HIPAA?
Well, I had mentioned it earlier about all the changes in technology, but basically when HIPAA was written back around 2000, it was written by CMS, the Centers for Medicare and Medicaid Services, and I don't think anybody, and this is not to blame anyone, envisioned the rapid growth of the internet, online technology, outsourcing of technology infrastructure. So In the old days, when you put in an electronic health record system, you put servers in your own location and you owned them and managed them. You could reach out and touch them. You knew where they were, and that was the concept of technology back around 2000. As the bandwidth changed, the cost of storage came down, and the internet kind of exploded. We now have online electronic health record systems. I'm sure there's some people on this call that are using electronic health record systems through the internet, where they just link into it. They don't have anything in their facility that has the patient data on it. That's all housed someplace else. Now, I bet if I asked a lot of them where that is, they probably couldn't tell me exactly where the servers are and where the data is located. So keep that in mind in terms of your responsibility to protect data, and you might not even know where it is. IT services have exploded. Back in the old days, in 2000 and before, everybody did what was known as break-fix services. You only called an IT company if something was wrong, and they came and they repaired it and sent you a bill for the repair and waited for you to call the next time you had a problem. Since 2000, the concept of managed services has kicked in a big way in the IT world because, again, there was a lot of bandwidth on the internet that allowed IT companies to do more work remotely and monitor networks. So instead of waiting for your system to break and then having you call them, a lot of IT companies went to a subscription-based service called managed services, where the IT services are paid for on a subscription basis, and you pay a monthly fee. The IT company monitors the network, does remote patching and updating, and essentially what you're paying for now is not having downtime. In the old days, you waited for downtime to occur and then you paid to have it ended. Now you're paying for prevention, and you're also seeing some of this moving into the healthcare world, where you pay for prevention with the idea that if they can keep you from being sick, it's better for everyone. And now you've got mass storage of patient records with third parties. So a third party being someone that's not the covered entity, the doctor's office, or the patient. Now you have IT companies. And we work with IT companies. Many of them don't have any data in their own infrastructure, but they're selling online backup. So their client's entire list of patients is, and all the medical records and images, for example, off of PACS systems are stored remotely with third parties. We have some IT companies that we work with that store data and make it available. So they're actually hosting the data for the healthcare providers and the payers. So they're third parties that are storing millions and millions of patient records. And for about the last 3 years, 20 to 30% of data breaches that have been reported, and these are over 500 patient records each, have been caused by business associates. So the government really took a look at all these things happening and realized that it needed to be able to enforce HIPAA directly on the business associates because they were causing so many of the problems. When 30% of the data breaches were caused by business associates, then the government had to act and make sure that the business associates complied and couldn't just force the penalties on the companies that hired them.
Give us some examples of some of those data breaches that are caused by business associates.
Well, if you go out to the Health and Human Services website, there's an area we call the Wall of Shame. That's not what they call it. They call it the data breaches for over 500 patient records. And there are a couple pretty significant ones, and there are a lot of smaller ones. So WellPoint is an insurer. They're a payer. And they had a third party, quote, accidentally publish 612,000 patient records on a website. And because the business associate couldn't be penalized, WellPoint, who hired them, was fined $1.7 million. So, you know, there may be people that are rolling their eyes or laughing at 612,000 records being published on a website, but this is a pretty good example that if you were a WellPoint customer or client, if you were insured by WellPoint and you were notified that your patient record was published on the internet, you'd be pretty upset, I can imagine. Keep in mind that many patient records also include Social Security numbers. So this is the big type of breach that can occur, and WellPoint was fined $1.7 million. Earlier this year, Omnicell, which is a company that supplies drug dispensing carts to hospitals, breached 68,000 patient records. Omnicell's drug carts are like these cabinets that are on the floors in hospitals, and a nurse could push them down the hall, for example, go to a patient room, and enter the patient's name. A drawer opens with their medications. The medication's dispensed, and then it's automatically updated with the patient record, but also into the billing system that the medication was dispensed. They had some sort of a problem, and a field technician went out and used his laptop and downloaded the patient records, or downloaded all the data off of the drug carts for 3 large healthcare organizations. His laptop was stolen, and 68,000 patient records were breached. The companies, the healthcare companies, the clients of Omnicell that hired Omnicell, each had press conferences and said how disappointed they were with Omnicell because they have a contract with Omnicell that says that Omnicell would only store data on encrypted laptops, and that Omnicell essentially had breached the contract. So Omnicell signed a contract with these healthcare providers, didn't live up to the contract, and breached 68,000 patient records. When I looked at this and thought about it, the questions that came into my mind were, when they signed a contract, there must have been some executives and some lawyers involved in the contract signing. That's how contracts work. My question was were the terms of that contract ever communicated to purchasing? So did Omnicell's purchasing department know that when they needed to buy a laptop for a field tech, that they had to buy an encryption program with it? Did the IT department that sets up the laptops know that a laptop should not be distributed to a field technician without encryption? Finally, did the field technician know that his laptop wasn't encrypted and that he shouldn't be putting patient data on that laptop for that reason? So this goes back to when contracts are signed, you can't just throw them in a file cabinet and forget about them until the renewal date. If the contract requires you to do something, then people should be familiar with what the terms of that contract are. And that needs to be communicated and maybe reminders sent so that people are in compliance with their own contracts. I also think that the healthcare providers had some responsibility here, and I think this is a good example of why the covered entities still need to be responsible for data breaches that are caused by their business associates. Omnicell signed the contract with 3 healthcare providers. It seems obvious, based on the data breach and also the press conferences where these providers said that Omnicell wasn't in compliance with the contract, that the healthcare providers hadn't done anything to validate that the tech that was walking around their facility with a laptop and downloading patient records off of their drug dispensing carts was using an encrypted laptop, which the contract said they had to do. So I think that the healthcare providers had some responsibility here to ensure that their vendor, Omnicell, was living up to its contract, and that they had the responsibility to the patients. They couldn't just blame Omnicell for not living up to a contract when both parties had signed it and the healthcare providers hadn't done whatever due diligence they should have or they could have done to ensure compliance with that contract.
Well, if a company is basically in denial about being a business associate and they won't sign a business associate agreement, what options does a medical practice have for dealing with that company?
Run. You have to run. And I'm serious about this. If you believe that a company that's providing you a service meets the requirements of being a business associate and they won't sign your agreement, and they claim that they're not a business associate and you think they are, you have no choice but to stop using them, because sharing any data with them at that point would be a data breach. That you're actually storing information or sharing information with someone that hasn't signed a business associate agreement, is not complying with HIPAA, and that by definition is a data breach. So you have to make sure that they have no data. So if this is an organization, for example, an IT company or an online backup company or a cloud vendor, and there was data stored there, you need to make sure that it's completely removed from them, and either come up with a different way to have the work done, or find a company that offers similar services but will sign a business associate agreement and will prove to you that they actually comply with HIPAA.
So then for companies that will sign the agreement, and you've touched on this a little bit, what do providers need to pay attention to in those agreements?
Well, I think that this does get down to due diligence. First of all, the way that the government handles business associate agreements, they did not create a form, and this has confounded some people and frustrated people. And I think from a legal standpoint, the government did not feel that two businesses that are doing business with each other, that they should dictate all the terms and conditions, because businesses can negotiate essentially most terms and conditions as long as they're legal, and do business with each other. You don't have the same protections, for example, that consumers have. So when someone gives you a business associate agreement, the first thing you need to do is read it. And if you go out to the Health and Human Services Department's website, they have a section called Business Associate Contracts. And the Business Associate Contracts has the required verbiage that has to be in those agreements. So essentially you can look at things that should be in there, and those aren't negotiable. But then look for other things. And the types of things that I've seen, I had an IT company come to me recently and say that they were presented with a contract by a healthcare provider, a covered entity, that said that they had to do criminal background checks on all of their employees that would come in contact with patient data. And that's not required by HIPAA. So their question to me was, what should we do? That's an expense to us. And my answer first was, I'm not a lawyer, but I can see, just like anyone can see, that that requirement is not listed as one of the requirements on the federal website. So as with any contract, you can negotiate it, and then you'd have to determine if it stayed in as a requirement, either you're going to pay for those background checks and absorb the cost, you're going to increase your rates to your client to cover the cost, or you're going to pass the bill directly across to your client. So when you look at a business associate agreement, there can be some gotchas in there, and it also can have terms that say, for example, a business associate is responsible for paying all the costs related to a data breach caused by the business associate. That, I think, is reasonable. I did see one recently, and I suggested that the person that showed it to me contact an attorney familiar with HIPAA, because as I read it, it said that the business associate was responsible for any data breach caused by the covered entity. And I really don't think that may have been what was intended, but that essentially said that if someone at the medical practice had caused a data breach, that their IT company or someone who may have been completely removed from the data breach would be legally responsible for it. So I don't know what happened with that, but that's always the point where we refer people to attorneys. One other question that comes up is, where does the business associate agreement come from? And it doesn't matter. It doesn't matter whether a BA agreement between a covered entity and a business associate comes from the covered entity or the business associate. It's simply a contract between two businesses, and either one can initiate that. When you're dealing with the subcontractors, you've got small companies that could be subcontractors maybe in a local area, and then you've got large subcontractors. For example, a company like Microsoft will sign a business associate agreement, and the Microsoft solution may be sold through an IT company. When we get to the larger companies, they're pretty insistent, and this happens, by the way, both on the covered entity side, but also on the business associate side. The larger the company, usually the more insistent they are that you will sign their agreement. And it's more a matter of cost management, where a large company like Microsoft, let's say they have 2,000 resellers out there, or maybe 10,000 resellers out there. If every reseller sent them a business associate agreement, they would have to have legal teams reviewing all of those agreements and spending a lot of time and effort and really not getting much for it, for the cost, to determine if it's something that they'd be willing to sign. Instead, they publish their own and say, this is our agreement. If you're a covered entity or a business associate and you want to do business with us that relates to HIPAA and protected health information, this is the agreement you will sign. So a lot of times we'll find agreements out on websites, or there are ways to request them. Just as an aside here, we've written articles, and for quite a while we've said that Google, for example, will not sign business associate agreements, and recently they changed it, but they didn't completely change it. So a lot of medical practices have liked using Gmail, and Gmail is the free email service. In this conversation, just for the sake of conversation, when we talk about Gmail, you can use Yahoo Mail or Hotmail or any of the mail services provided, for example, free by an internet service provider like Cox or Comcast or Time Warner. That any of those free mail services are nice to have, but they're not appropriate for communicating protected health information. For a long time, Google would not sign a business associate agreement. In September, they announced that if you're using the paid Google Apps for Business, which does have a business version of Gmail, that mail is secure. They will sign a business associate agreement, but they still will not sign a business associate for free Gmail. So no patient information should be communicated by a medical practice using Gmail.
Before we continue, I just want to remind our guests we've had a couple of questions about getting the slides in the recorded version. We will be sending those out after today's session, so look for those in your inbox over the next couple of days. And let's continue. We also have questions from our audience that we'll get to here shortly. So if you've touched on this already, Mike, but if a company signs a business associate agreement, then it's compliant with HIPAA, right? That's all they really need to do?
Well, right, Brian. As I said, that's wrong.
Right.
The business associate agreement is the legal document that the two organizations have to have with each other. However, it's just the tip of the iceberg. That there's a lot of work that organizations have to do, and if you go back to that discussion at the very beginning about the types of organizations that are business associates and the wide range of them, there are many different things that each one would have to do. Now, written HIPAA policies could be pretty generic and look similar between a lot of different types of business associates. However, when you get down to the next item, HIPAA-compliant written procedures, that's a huge area. And we've worked with companies, some cloud vendors that offer services through the internet, online backup companies, cloud vendors, etc., that have literally spent months tearing apart every one of their processes and looking at it to determine if it's HIPAA compliant, so it's not a direct violation of HIPAA, but then also from a risk management standpoint, if they're incurring risk or if there's risk that their business partners or their customers are incurring when they do business with them. And there's just way too much detail than anything we can go into on the phone here, or on this webinar, but this is where it bogs down. That HIPAA compliance procedures require a business to look at everything that it does that relates to protected health information, and in some cases the cloud vendors can't segregate protected health information. If they have 1,000 customers, and particularly now that business associates have to comply, they can't look at their list of customers and say, well, we only need to use HIPAA compliant processes if the client's name is a medical facility or a medical practice or an insurance company, a health insurance company, now you have the doctors, you have the lawyers and the accountants and the shredding companies and the IT companies and the cloud vendors, and every one of them must comply with HIPAA. So it's really something where a cloud vendor, say an online backup company, has to look at all the data that comes to it as potentially being protected. Now, everything we're talking about on this call, because of the nature of the business we're in, relates to HIPAA. But there are also some state regulations, and there are also some other federal regulations that protect other types of data. So these companies are also working, for example, with banks or financial institutions where the information that they're storing is financial data, but it's as protected as healthcare data. So when you're dealing with these HIPAA-compliant written procedures, this is where the companies have spent a lot of time and effort reviewing what they do, and in some cases every step of a process and what tools they're using for storage, for encryption, for transmission of data back and forth across the internet. In some cases there's a physical aspect to it, so there are still companies that back up to tape and also to hard drives, and those hard drives and tapes are physically transported to off-site storage facilities, so if the building burns down, all the data is not lost. That's the hard part. Everybody in the workforce that is somehow related to the protection of health information has to have training, and it has to be HIPAA-specific training. And then you have to have HIPAA-compliant documented service delivery. So when we're looking at these things, if you look at this list, you'll see HIPAA-compliant written procedures, HIPAA workforce training, HIPAA-compliant documented security delivery, and written HIPAA policies, where a lot of companies fail the test, the taste test or the smell test, however you want to describe it, to determine if they're really compliant with HIPAA, is the way that they'll answer some of the questions. So we'll ask a data center, are you HIPAA compliant? And they'll say, yes, we've passed an SAS 70 or an SSAE 16 or a SOC 2 audit of our security practices, so we're compliant with HIPAA. That's not the case. That's not true, because those other data center types of certifications are not specific to HIPAA. So an auditor that's going to come in from HIPAA to audit for HIPAA compliance will not care that there's a SOC 2 audit report for the security of a data center. They're going to want to see a HIPAA risk analysis that complies with the HIPAA regulations. They're not going to want to know that the patient data is protected and that people have been trained to encrypt their data. They're going to want to see records of HIPAA-compliant workforce training to make sure that those employees are trained in HIPAA. When it comes to service delivery, they don't want to see that just basic security measures have taken place or that data has been transferred. They want to see that it's been transferred in a way that's compliant, and the dots that connect are that there's a policy that says the organization is going to do things to comply with HIPAA. The procedures say how they're going to do things. Their workforce will be trained in how they do things, and then there has to be evidence, documented evidence, that the work is actually taking place. So all of these things connect, and this is where a lot of business associates fail when you start asking the hard questions about what they're doing to comply.
So I think you've talked about all of these things now, but just maybe run through again what is required to be compliant.
Well, written policies, and you can't have a one-page security policy and be able to validate that you're complying with all 50-some sections of the HIPAA security rule. You can't have processes that aren't documented. When you're audited, they don't ask, what do you do? They ask, do you have evidence of your procedures that people have to follow? So when we talk about procedures, you can think of them as checklists. And checklists are paper types of checklists that have been developed and revised over time and shared with employees so that they know what to do to comply with HIPAA. A HIPAA risk analysis is literally the first requirement of the HIPAA security rule. And a risk analysis has to look at the vulnerabilities and the threats that could affect the security of patient data. So these are all specific documents that you could ask for and people should be able to hand you or share with you. And then evidence of workforce training, you don't say, well, we train our employees and we do it once a year and it's a pizza, lunch and learn. What you have to do is be able to show that there's evidence, sign-in sheets, for example, and copies of the types of training that people have received. And it's interesting that there's a picture of a doctor on this slide because one of the requirements for workforce training specifically says including providers. So when we work with medical organizations, we'll find that the staff, the billing office, the practice manager, and the administrative staff, the receptionists, and even the nurses may have all received HIPAA training, but the doctors were too busy. Well, it doesn't matter. That's not an excuse, and HIPAA requires that the practitioners and the providers also be trained and that management of organizations be trained. When I was the CIO in a hospital, I was the one that went to my boss, the CEO, and said, what time do you want to do your HIPAA training? And he smirked and realized that he couldn't evade it and went and did his HIPAA training. But that was because the requirement says that the providers and the management also has to be trained. And here it says other evidence validating compliance. Evidence is truly paperwork, work tickets, sign-in sheets, some sort of record that something happened, and it could be a note in a patient chart, for example, but from an IT company's perspective, it also could be evidence that the backups of patient data are actually taking place because there's a requirement for the data to be protected.
So for vendors who are trying to become HIPAA compliant, is this something they can do on their own?
My experience is no. And the reason is that I've talked to a lot of vendors. And most of the vendors are really experts in their fields and what they do. And they may have some people that are familiar with IT security. And IT security is the world that I came out of. So I had a good understanding of that. It's quite different than what the compliance requirements are. Because when it comes to IT security, a lot of that is technical security. And better than half of the HIPAA security rule is administrative processes that you need to go through to make sure that your workforce is protecting the data and that your organization has the policies and procedures in place. And my experience is the larger the organization, there are some small organizations that may be able to go through and use some of the government guidance and some information that's out there to try to do it themselves. But even the government says, and this is in the context of the risk analysis, doing a thorough and professional risk analysis, and these are the magic words, that will stand up to a compliance review, will require expert knowledge that could be obtained through the services of an experienced outside professional. What they're really saying here is that you can do it yourself, but will it stand up to a compliance review? And that's where professional assistance has been required. And as I've worked with a lot of these vendors, and particularly the larger ones with people in different departments and people with different levels of responsibility, that they've needed assistance because it got down to the specific things they were doing, and they didn't really need to understand HIPAA, but they needed the project led by someone that did.
Now, this is something we've touched on before, and I think it's a question that a lot of people have. How can a practice know, that its business associates really are complying? If they sign the agreements and they say that they're compliant, how can they be sure that that's actually true?
Well, first of all, I think you have to have a conversation, and the conversation could be done informally. Partly, it may be based on the size of your organization or the size of their organization, how formal the process is, but and how many business associates you have. But I think you need to talk to them. If you're a small practice and you're dealing with a small IT company, for example, ask them what they have done to comply with HIPAA beyond signing the business associate agreement. And we've already given you some things here that you can look for. The other thing is, I think you need to be wary. And this goes back to President Reagan, who used the term trust but verify. And it doesn't mean you don't trust somebody when you ask for evidence, but when your compliance, when you could have millions of dollars of penalties on the line because of something that one of your vendor does, it's a fair question to ask them for evidence. And then the last choice is that if you're not comfortable doing it, or if you don't have the wherewithal in your organization to do it, bring in a professional consulting company to audit your vendors and validate their compliance. And you can require them, your vendors, to have an assessment and even pay for it if they want to do business with you. That gives you a third-party view of what the vendor is doing, and that would be the equivalent of having the government do an audit without risking the penalty of fines. If it comes back negative, for example, and the vendor's not living up to HIPAA, you can work with a vendor to get them compliant or give them time to become compliant without having any risk to your practice. That's a reasonable approach to this, as long as you don't continue to use them too long after you've identified weaknesses and that they still may be continuing.
Well, I'm afraid we ran a little long, so we don't really have time to answer questions. We did have some interesting questions about business associates, so I'd like to encourage our audience to look for the follow-up email we're going to send out. We'll share your questions with Mike, and he provides excellent written answers to those questions. So if you've asked a question today, or if you're just curious about what other folks may have asked, keep your eyes open, look in your inbox for that email where we'll provide written answers to those questions. I'd like
Brian,
to thank you.
I'm sorry for going long, but
no, it's
Brian, I'm sorry for going long, but is there one question that you think we could give a quick answer to?
All right, maybe we can do a quick one. Well, we've got some different ones here. Questions about pharmaceutical companies that are kind of interesting. But I'll ask this question about breach insurance because insurance isn't something we've talked about very much. So again, there's lots of questions. We'll just answer this one as quickly as possible if that's possible at all. The question is, if we as a physician office are requiring our business associates to obtain data breach insurance, should we provide them with a list of agents that can provide it to them?
Well, I'm not sure that you have to provide a list of agents, but I think there's some things, because I deal with this, my company's insured, and some of the companies that provide breach insurance and say that they're covering certain things have quite different views of what that is. So from an insurance standpoint, my answer would be simple. Look hard at the policy and work with the agent that you're working with to make sure that they understand what you do and that you're going to be protected and that your clients are going to be protected if something bad happens. Not all insurance coverage is the same, even though they may be similar policies by name.
And then I'm going to shoot you one other super quick one because it's kind of a fun question. The question is, our backup is stored in a bank vault. Do we need to have a BAA with the bank?
Well, it's an interesting question, and based on the new ruling, I think the answer is yes, because even though it's locked in a bank vault, it's stored at the bank, and the bank is maintaining it using the HIPAA verbiage, even though they don't look at it. I think the answer is yes.
All right. Well, thank you for joining us today, Mike. Lots of great information. It's quite all right that you went over, and as I said, we've got some interesting questions, so I just encourage everybody to look for your follow-up on those. I'd also like to thank all of our guests for joining us today. Remember that all registered attendees will receive an email with links to both the slides and the recorded version of this session. Format Approved offers convenient, robust online education on HIPAA rules and regulations, including updated business associate agreement templates. Visit www.formatapproved.com/education/courses_security to learn more about our HIPAA training. That training was authored by Mike Semel, I should mention. If you need a meaningful use risk analysis or HIPAA documentation, visit the second link on your screen, that HIPAA Secure link, because we also provide those services in association with Mike Semel as well. Visit formatapproved.com to learn more about our upcoming learning lunches. The Learning Lunch button on the bottom of the screen will take you to the registration page for our upcoming webinars. Our next Learning Lunch will air on December 4th and will cover the subject of how to identify the right HIPAA consultant. Keep an eye on your email box on our homepage for other upcoming topics, and thank you again for joining us today.